Dear readers, reading of circular number 214 of 1 of 2023, service tax dated 28th of February 2023, published by CBIC on the subject leviability of service tax on the declared service, agreeing to the obligation to refrain from an act or to tolerate an act or a situation or to do an act under clause E of section 66E of the Finance Act 1994. Issue has arisen on the levy of service tax on liquidated damage arising out of breach of contract, forfeiture of salary, or payment of bond in the event of the employee leaving the employment before the minimum agreed period, and similar other issues arising out of Clause E of Section 66E of the Finance Act 1994. Reference has also been invited to Circular 178 of 10 of 2022 GST dated 3rd of August 2022 regarding applicability of GST on liquidated damage, compensation and penalty arising out of breach of contract or other provision of law, and its applicability to service tax related issues. It may be seen that agreeing to the obligation to refrain from an act or to tolerate an act or a situation or to do an act is a declared service as per clause E of section 66E of the Finance Act 1994. A service conceived in an agreement where one person agrees to an obligation to refrain from an act or to tolerate an act or to do an act would be a declared service under section 66E clause E, read with section 65B 44, and would be leviable to service tax. The description of the declared service in question, namely agreeing to the obligation to refrain from an act or to tolerate an act or a situation or to do an act, is similar in GST. Agreeing to the obligation to refrain from an act or to tolerate an act or a situation or to do an act has been specifically declared to be a supply of service in para 5 clause E of schedule 2 of the CGST Act 2017. As can be seen, the said expression has three limbs. Number one, agreeing to the obligation to refrain from an act. Number two, agreeing to the obligation to tolerate an act or a situation. Number three, agreeing to the obligation to do an act. Service of agreeing to the obligation to refrain from an act or to tolerate an act or a situation or to do an act is nothing but a contractual agreement. A contract to do something or to abstain from doing something cannot be said to have taken place unless there are two parties, one of which expressly or impliedly agrees to do or abstain from doing something, and the other agrees to pay consideration to the first party for doing or abstaining from such an act. Such contractual arrangement must be an independent arrangement in its own right. There must be necessary and sufficient nexus between the supply, that is agreement to do or to abstain from doing something, and the consideration. The issue also came up in the SISTAT in appeal number ST 50080 of 2019 in the case of Messrs. DY GM Finance Bharat Heavy Electrical Limited, in which the Honorable Tribunal relied on the judgment of Divisional Bench in the case of Messrs. Eastern Coalfield Limited versus CC Raipur. Board has decided not to file an appeal against the CSTAT order STA 50879 of 2022 in this case, and also against order dated 12th of August 2022 in case of Messrs. Western Coalfield Limited. Further, board has decided not to pursue the civil appeal filed before the apex court in Messrs. South Eastern Coal Field Limited, Supra, Messrs. Pradeep Port Trust, and Messrs. Navy Lignite Corporation Limited on this ground. In view of the above, it is clarified that the activities contemplated under Section 66E Clause E, that is, when one party agrees to refrain from an act or to tolerate an act or a situation or to do an act, are the activities where the agreement specifically refers to such an activity and there is a flow of consideration for this activity. Field formation are advised that while taxability in each case shall depend on the fact of the case, the guidelines discussed above and the jurisprudence that have evolved over time may be followed in determining whether Service tax on any activity or transaction need to be levied, treating it as service by way of agreeing to the obligation to refrain from an act or to tolerate an act or a situation or to do an act. Content of the circular number 178 of 10 of 2022 GST dated 3rd of August 2022 may also be referred to in this regard. Difficulty experience, if any, in implementing the circular should be brought to the notice of the board in the version will follow. Thank you.